National Prosecuting Authority believes the wheels of justice are starting to turn on complex corruption cases. The Gauteng High Court recently granting a preservation order to the Asset Forfeiture Unit of the NPA against those who were involved in the financing of the purchase of Optimum Coal Mine for an amount of 2.1 billion rand. This was back in 2016, and you remember who were the people that purchased that mine, the Guptas, through their Tegeta company. Joining me now to touch on this case and possibly others is the Deputy National Director of Public Prosecutions at the Asset Forfeiture Unit Division, Advocate Ouma Rabaji-Rasethaba, joining us via the virtual platform from Silverton, Pretoria. Advocate, thank you very much for your time. This case highlighting the coordinated approach as per a recent article you wrote. This coordinated approach, both from prosecutors within the NPA working alongside the Hawks. Bring us up to speed, first and foremost, before we break down how you managed to crack this case. Bring us up to speed as to where the case is right now after the preservation order was granted to you by the courts.
Thank you very much, and good morning, Collie, to you and the listeners. And where we are with this case is that we have obtained the preservation order, as we've said, which is a freezing order, to freeze the Optimum Coal Mine, the Optimum Coal Terminal, and we had a second application which we brought simultaneously, which are all the claims that are being brought by a Gupta associate to the value of 1.3 billion. So the court simultaneously appointed a curator to have an oversight over the running of the mine, parallel with the business rescue practitioners that are in place. The curator has obtained letters of curatorship, which is done through the Master of the High Court. The curator has since paid security, which is, a process that he has to follow. And he has to evaluate the mine and bring it to life. So the operations continues. They don't cease. And then within 70 days, he has to file a report in court, which will explain the assets, the liabilities, the creditors' claim. We've got, according to the investigations that have been done thus far, 134 creditors. Of course, some of them, then he has to advise the court which one are preferent creditors, and he has to also, within 70 days, evaluate the mine, and we need to know what is the full market value of the mine.
All right.
So that's where we are.
Okay. So the central role that will be played by the curator who was appointed by the court will be to do what exactly in simple language?
In simple language, to have an oversight role over the mine, over the running of the mine, to make sure that the mine continues operating, to finally sell the mine, so that during forfeiture, right, within 90 days of this court order being published in the government gazette. So that's what the curator has to do. So we need to get the highest buyer for the mine, the bidder for the mine, so that people get back their jobs and the mine is going to operate. So we basically want this national asset to stay in South Africa. So we prevented it from going back to the Guptas through money laundering. The
value of the mine?
The value of the mine, the 3.4 billion figure that's in the court order, it's a very conservative figure, in the sense that only now the curator starts operating. Only now he's going to evaluate the mine. Only now he's going to tell us what are the liabilities, what are the assets of the Optimum mine. and then he'll give us a value in the report within 70 days that is going to file with the registrar of the court.
Yeah. Where does this put the business rescue practitioners?
So the business rescue practitioners are appointed in terms of the Companies Act. So you do know that they opposed the application and said that the Companies Act crimes, the Prevention of Organized Crime Act, which is the act the NDPP used to freeze this mine. So the court did not accept that argument from the business rescue practitioners, and they are going to work with the curator who's representing the state interest, if we could call it that.
Yeah.
And the court order says they must work together in good faith. So we've managed to reconcile the operations of the two acts.
Okay. Let's get to grips then, Advocate, with how you managed to put this case very plainly before the courts and allowing, therefore, the courts, or in a way, motivating for why the courts ruled in the manner in which they did. You used these words in your article, which post the court ruling, you set about explaining how this entire scheme worked. You said, and I quote, "The scale and scope of the heist at Optimum is unprecedented." Break it down for us. What were you describing there?
So what we are describing here is that from the investigations that the Hawks and our colleagues at the investigating directorate within NPA did, it's clear that money was stolen from South Africa, from Transnet Benefit Fund, and then some of it was transferred overseas, Bank of Bermuda, into 3 companies of the Guptas, into Bank of Baroda, get a loan from Bank of Baroda, and then it came back to South Africa to purchase the mine. So that's one amount. Then there's another amount that left Eskom Direct to purchase the mine, and all these 8 transactions of how the money made it to have the Gupta's purchase this amount were held in an extra account to help them to where the funds had to be held for the purchase of the mine. So some went overseas, came back, some went direct, and what we did was to show the financial flows in the investigations, that these are all process of crime. It's money stolen from the South African coffers, from South African companies that were then laundered, were washed to come back into South Africa, into that account, and then they made the full purchase price of approximately 2 billion to purchase. So we then went to court and said there are reasonable grounds to believe that these are process of crime, and the crime is theft, money laundering, corruption that has enabled them to buy this mine.
On that point, Advocate, just on that point, let me ask you this question. Who were the main actors from the side of the Guptas, first and foremost?
Obviously, we have looked at bank accounts, right? We've looked at accounts, bank accounts, we've looked at Griffin Line, we've looked at, and some of the accounts are in Bermuda, we've looked at the accounts of regiments, Albertine, Trillion. So, of course, they used a lot of accounts. And then the money went into Sahara Computers, Island Investments, Ogbe Investments, which are Gupta companies. And that's how the laundering was done. So it's done through bank accounts of companies. And then it went, and then they got a loan vis-a-vis these companies from the Bank of Baroda.
Right. So the laundering was done through companies. But South Africans...
The laundering was...
Indeed. But South Africans will be interested to know who the faces are going to be if and when South African law enforcement agencies are successful in bringing back the Guptas from wherever they are in the world? Who are some of the faces that they are likely to see if successful in bringing these people to book?
The South Africans are going to have to wait for finalization of the criminal case, and when these people are prosecuted, when there's solid evidence, because remember, we don't go after people, we use evidence to prosecute people as the National Prosecuting Authority. I used a civil standard. I just needed to prove to court that on reasonable grounds to believe these are proceeds. So that's a lower standard. So I can give a lot of names that appear that facilitated this transaction, but those may not translate into prosecution. They might not be evidence that will be suitable for criminal standards. So let us wait. A lot of good work has been done. The investigations will be concluded, and this was just the first start. And the right people will be prosecuted when the evidence is strong against them.
Yeah. All right. So the theft of public funds, the theft of South African taxpayers' monies, allegedly by the Guptas, would not have happened, Advocate Rabaji-Rasethaba, without the participation of those employed at state-owned enterprises like Eskom in the facilitation of this particular deal, for example. Are you able to tell us about any names at Eskom, for example, that were intimately involved in facilitating some of the contracts to the Guptas, coal contracts, that is?
As I've said, I'll be able to say a lot of names, but that may not translate into criminal prosecutions, and I think that would be unfair because we don't reveal who's being investigated and who's going to be prosecuted at NPA. So I think maybe let's leave that at this point.
Okay, fine.
But the most important message being, I have used a civil standard.
Yeah.
So as I've said, there are a lot of names. The papers that we have filed in court are public knowledge. If you go through those 13,000 pages of the case that we placed before the court, you will see some of the names. But they may not translate if the evidence is not strong enough, because it's got to be beyond reasonable doubt to meet the criminal standard.
All right, I understand that. I understand that yours is to follow the money. But let me try and put this question to you. How strong is your evidence against those that were leading Eskom at the time of the facilitation of these contracts? Simply put, they obviously... Yeah, go on.
So, sorry about that. For purposes of the freezing order, for purposes of Asset Forfeiture Unit, I have made out a strong case. As I've said, the court papers are public knowledge. I have made out a strong case, and I've got a court order. What I'm waiting for is for people to come through and say, my interest must be excluded. I am seizing assets. I'm forfeiting the mine back to the state. It's our national asset. I will not allow as Asset Forfeiture Unit to allow the mine to be taken away by the Guptas. So the proceedings that I have instituted, it's an action in rem. It's action against the property.
Yeah. All right. You did use these words, and I found them quite interesting in your article, and I'm going to quickly read here. You said, rules were broken to steal and rush through contracts to benefit Gupta companies. So, again, I ask you, just how strong is your evidence against those that were leading Eskom in facilitating these contracts?
My evidence is strong enough to have allowed me to obtain a court order against the property, against sale of the property by the business rescue practitioners. So my case for the civil standard that I'm using, which is reasonable grounds to believe, was strong enough to stop the sale of the mine.
And are we at some stage going to see civil action being taken against certain executives? In other words, attaching of property that you would have believed would have stemmed from either the greasing of hands as a result of certain contracts going through, that they would have benefited as a result of these shady deals?
Yes, where there's evidence on balance of on reasonable grounds to believe, and for forfeiture state, on balance of properties, yes, definitely. I am going to take away the process of crime and ill-gotten gains from the unlawful activities that occurred.
Let's move away slightly from the Optimum Coal Mine case, Advocate. If indeed this is now going to be the golden standard by the NPA, and what do I mean by that? You have said right at the beginning that this was as a result of the coordinated effort by the NPA working alongside the Hawks to break through this complex criminal case, financial crime that is. People are wondering, why is it taking so long for you to crack the Steinhoff matter? Because South Africans, and I want to believe many of them are, very appalled at the moment by the fact that people like Marcus Jooste are still walking around free in this country.
Cody, as I've said, these cases are very complex. You need to follow the money. You need to request for financial statements from foreign jurisdictions. We follow a process in terms of the law. And I can confirm from working with my colleagues in DPCI, they are hard at work in investigating the case. So you will recall that we don't investigate. And here I'm representing Asset Forfeiture Unit, and I've explained the standard. And I think South Africans must be patient. We will definitely crack these cases. They are being investigated, and prosecution services, my colleagues, will definitely, once there's sufficient evidence that will stand in a criminal court, they will definitely follow up and prosecute these cases. So let us all be patient.
Advocate Ouma Rabaji-Rasethaba. She is the Deputy National Director of Public Prosecutions, leading the Asset Forfeiture Unit Division.